Welcome to The Explainer. Today we are diving into a really powerful legal concept. It's like a special toolkit that courts use to make sure that the government plays by the rules and doesn't overstep its boundaries.
It's one of the most fundamental questions for any democracy. Think about it. When a government body, say your local council or a ministry, makes a decision that affects your life, who gets to double-check that they were actually allowed to make that decision in the first place? Who's the ref?
Well, the answer is a process called judicial review, and that referee analogy is a pretty good one. The court's job isn't to say whether a decision was a good idea or a bad idea. They're not interested in the politics of it. All they care about is one simple thing. Was it legal?
So how exactly does this referee make the call? Well, judges have a very specific set of tools, or grounds, they can use to challenge a decision. We're going to walk through the big ones: illegality, irrationality, procedural impropriety, and a really interesting newer tool called proportionality.
Okay, first up is the most basic, most fundamental tool in the entire box. It's the ground of illegality, and honestly, it's the bedrock of this whole system.
What this really boils down to is that a public body can't just do whatever it feels like. It can only do what Parliament has legally empowered it to do. If it steps 1 inch outside of those legal boundaries, it's acting ultra vires, which is just a bit of fancy Latin for beyond the powers.
Now, illegality isn't just one thing. A decision can be illegal for a few different reasons. Maybe the authority used its power for a purpose it was never intended for. Or maybe it attached a totally unfair condition to a decision. Or it could fetter its discretion, which basically means it's chained itself to a rigid policy and refuses to even consider the specifics of an individual case.
Let's make this real with a classic example. It's a case called Attorney General versus Film Corporation. So this council was given a very specific power by law. It could set up wash houses where local residents could come and do their laundry. Simple enough, right? Well, the council decided to get a little creative. Instead of just providing a facility, they opened a full-on commercial laundry business to make a profit. The court had to step in and say, whoa, hold on. Parliament gave you the power to provide a service, not to run a business. You used your power for an improper purpose, and because of that, your decision is illegal. And here's another example. A public body really can't hold you to ransom. In one case, a council gave a developer planning permission, but only if the developer built a whole new public road, entirely at their own expense. The court said, absolutely not. That's what's called an onerous condition. You can't just force a private individual to pay for a public benefit like that.
Okay, let's move on to our next tool. And this one is less like a scalpel and more like a constitutional sledgehammer. It's only brought out for the most extreme, mind-bogglingly bad decisions.
It's officially called irrationality, but pretty much everyone knows it by its famous nickname, Wensbury unreasonableness. And you just have to read the definition to understand how incredibly high the bar is set for this test.
I mean, listen to that language. So outrageous in its defiance of logic. We're not talking about a decision that you and I disagree with, or even one a judge thinks is a bit silly. We are talking about a decision that is just completely off-the-wall bonkers. A decision that makes absolutely no logical sense whatsoever.
So you might be wondering, why on earth is the standard so high? And the answer gets to the very heart of how our democracy works. Judges are not elected. Their job is to interpret the law, not to make policy. So this super high bar acts as a crucial safety valve. It ensures that courts only step in when something has gone profoundly wrong, respecting the fact that political judgments are for elected officials to make.
All right, on to our third tool. With this one, we're shifting our focus a little bit. We're not looking so much at the final decision itself, but at how that decision was made. Because sometimes a perfectly reasonable outcome can be unlawful because the process to get there was totally unfair.
This ground is called procedural impropriety. It sounds a bit technical, but really it's all about fair play. It's about making sure that public bodies follow the rules of the game before they make a decision that's going to affect somebody.
And this idea of fair play really has two parts to it. The first one's pretty simple. If a law says you have to do something, like consult the public before you act, then you've got to do it. But the second part is deeper. It's about the unwritten, common-sense rules of fairness that courts have developed over hundreds of years. We call this natural justice.
And maybe the most important rule of natural justice is the rule against bias. The Latin phrase for it is nemo judex in causa sua, which just means no one should be a judge in their own cause.
It's all based on that famous idea that justice must not only be done, but it must be seen to be done. And for that, you need an impartial decision-maker.
A really famous case that shows this in action is the General Pinochet extradition case. One of the High Court judges hearing the case had ties to Amnesty International, which was one of the groups arguing in the case. Now, nobody suggested the judge was actually biased, but that wasn't the point. The mere appearance of potential bias was enough. The decision was scrapped, and the case had to be heard all over again by a new set of judges, just to protect the integrity of the process.
The idea of fairness also creates something called a legitimate expectation. Basically, if a public body makes a clear promise to you, or if it has a consistent, long-standing way of doing things, you have a right to expect them to stick to it. The courts can actually step in and hold them to that promise, unless there's a really, really good reason to change course.
Okay, finally, let's look at our last tool. This one's a bit more modern, a bit more intense, and it's become hugely important, especially in cases that involve our fundamental human rights.
This slide gets to the heart of a really big shift. Remember that Wednesbury sledgehammer we talked about, which just asks if a decision was completely outrageous? Well, proportionality is much more like a surgeon's scalpel. It's not one big question. It's a structured, four-part test. It asks, 1, is the government's objective legitimate? 2, is the action rationally connected to that objective? 3, was it necessary, or could they have done something less intrusive? And 4, and this is the big one, does it strike a fair balance between what the community needs and the rights of the individual? It's a much deeper dive, and it forces the government to properly justify its actions.
So let's pull all of these different tools together and think about what this all means for the balance of power between the government, the courts, and, well, us.
So, there you have it, the judicial toolkit. You've got illegality, asking if they even had the power to do it. Irrationality, asking if the decision was just plain absurd. Procedural impropriety, asking if they played fair. And proportionality, asking if they got the balance right. Together, they form a powerful system for holding power to account.
But this all leaves us with a huge, ongoing debate. Is judicial review a vital check that protects our freedoms and upholds the rule of law? Or is it a step too far, where unelected judges start getting involved in political decisions? Finding the right balance there, well, that's one of the biggest and most important challenges for any democracy.